This is one of those cases that hits hard right from the start. A young man standing in court, facing a life-altering decision after a single, devastating choice. What makes this case so gripping isn't just the crime itself, but the circumstances behind it. We're talking about someone with limited criminal history, someone who, by many accounts, wasn't deeply embedded in a life of crime, yet somehow ended up committing an aggravated robbery with a firearm. Now here's where it gets complicated. The defense paints a picture of desperation. A young man trying to help his struggling family, trying to keep the lights on at home. But the prosecution? They see something entirely different. They see a dangerous pattern, a willingness to use violence, and a threat to the community that cannot be ignored. And the judge? She's stuck in the middle of these two narratives: rehabilitation versus punishment. Second chance, or 25 years behind bars. So here's the question for you. When someone commits a violent crime for what they claim is a good reason, does that change how they should be punished? Or does the act itself outweigh everything else? Let's break this case down.
5 DCCR 1759. Mr. Fontinet, I understand that this is harsh, and I know you believe this is harsh, but I think this is necessary. I'm going to find you guilty of aggravated robbery. I'm going to sentence you to
a way out of the situation that he's in, so he goes here. He's got a limited criminal history. I believe this is his first felony. He's never been on any kind of felony supervision. Or felony probation. Unfortunately, he's just fallen into the same situation that we see so many other youthful offenders fall into. He's got no direction in life. He's very little support at home. Sees no way out of the situation that he's in, so he goes and decides to rob a store and get some money. Did the wrong thing. And if his story in the PSI is to be believable for what I believe is the right reason, he's trying to help his mom out at home, he's trying to pay some bills, keep the lights on. Certainly there are better ways to go about doing that. And I hope that the time in jail has taught Mr. Fontinet that. So you're done. We've got options here, Judge. We can send him to prison or we can put him on probation. Certainly he's on the road. If his conduct continues, he's on the road to prison. I don't know that the day is the best time to make that exit for him.
Is he okay, there he is. All right.
He's got a long life to live. We can send him to prison. He can be there for a few years and come back out. I don't know that he's going to get the help that he really needs in prison. There are programs available on probation that if he's serious about turning his life around, like he says in the PSI, those programs can help him. And if he does take advantage of those, it in turn would make the community a little bit safer. Because there'd be one less guy running around with a gun when he does get out of prison, if that were the road that you chose to take. Planning on living at home with his mom. I think he has some younger siblings there. To his benefit, before he was even arrested, he started a GED. I think on the night that this happened, he had just finished a GED class and made a dumb decision to go hang out with these guys that he should not have been hanging out with, and did this robbery.
This is where the case really starts to split into two competing philosophies of justice. On one side, the defense is practically pleading for an opportunity, probation, rehabilitation programs, a chance for this young man to turn his life around before it's too late. And they're not wrong about one thing. Statistically, structured probation programs can reduce repeat offenses when the offender is actually willing to change. But here's the problem. The entire argument depends on potential, not proof. Not a track record of reform, just the hope that he might make better choices moving forward. And that's a huge gamble, because the judge isn't just responsible for this defendant's future, she's responsible for public safety. If she gets this wrong, it's not just one life affected, it could be many. So let me ask you this. If you were in that courtroom, would you take the risk on rehabilitation, or would you prioritize protecting the community no matter what?
Again, Judge, you've got two options. You can send him to prison, or you can try to get him some help on probation, and hopefully he will take advantage of that. And certainly if he doesn't, we're going to know pretty quick, and you'll have another chance to send him to prison probably for a longer time.
All right, thank you. What is the status of the other two Are there co-defendants? Have they been charged?
They have been charged, Judge, and I have both of their cases, Judge.
And they have not been sentenced yet or
No,
anything
Judge.
like that?
No,
Okay.
Judge.
All right, go ahead, Mr. Coleman.
Yeah, I'll be brief. Whether it's the Pine Club Apartments or Rogers Park or a Speedy Mart, you've seen this, and we've seen this in this community all too often. I'm preaching to the choir, Judge. Prayer vigils and advisory committees, all that stuff's fine, but you judge where the rubber meets the road. You are that person that can protect the community from somebody like this defendant. You are that person that can either let him walk out of this courtroom on probation with a piece of paper with conditions and promises that he won't resort to this kind of violence that you saw on that video, or you can ensure that the community is safe by putting him behind steel bars, concrete wall, and razor wire fence. Judge, I'm just asking, I'm not in the habit of begging, but on behalf of this community, I'm begging that you sentence this defendant to prison. The message that needs to be sent to this defendant and his circle of friends and anybody who would want to be like this defendant is that if you pick up a gun with the intent to commit violence, you're going to pick up a 15, 20, 25-year prison sentence, Judge. And I'm just asking that you do this on behalf of people who live at the Pine Club Apartments, who just want to live in peace, people who want to go take a walk at Rogers Park and not be robbed, and somebody that wants to stop at a Speedy Mart convenience store and pick up some snacks without becoming a victim of a robbery.
That right there, what you just heard, is one of the most powerful prosecution arguments you'll ever see in a courtroom. Notice how the focus completely shifts. It's no longer just about the defendant, it's about the victims, the community, the everyday people who just want to live their lives without fear. The prosecutor isn't just asking for prison time. He's sending a message, a warning. He's essentially saying, if the court goes soft here, it sets a precedent. And in cases involving firearms and violent robbery, precedent matters. But here's where it gets even more intense, the emotional angle. He paints vivid scenarios, families walking in parks, people shopping at convenience stores, workers just trying to get through their shift safely, and suddenly, this case becomes bigger than one defendant. It becomes symbolic. So now the stakes are crystal clear. Is this about giving one young man another chance, or about drawing a hard line to prevent future violence?
That's all I have, Judge.
Thank you, Mr. Coleman. So, Mr. Fontinet, there was a time some years ago that there really wasn't even a question. State's attorneys were recommending youthful offenders, probation, let's give everybody an opportunity. And things have just changed in such an incredibly dangerous way with young people doing what I just saw you do on that screen. I cannot imagine the fear that that person had that was working in that store, that he now has, just trying to go to work, make a living, and go home. And he has 3 people come in and not just grab a little quick something and run out, but terrorize him for quite some time. Pulling him around, yanking him around, putting guns in his face, all 3 of you. I also, in addition to the PSI, get jail incident reports. And you apparently like to fight and jump people, which is what's been happening in the jail. So it makes it very difficult for me to go, oh, this is somebody that's going to get out and behave, who can follow the rules, because you can't even follow the rules in jail. And the pre-sentence report shows that you're a high risk level, which tells me that after they've looked at everything, that you don't have, unfortunately, a good likelihood of being successful if I were to put you on probation. And Mr. Coleman's right. We're tired of it. And there's got to be something done. So in cause number 25, DCCR 1759, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. And at this time, I'm going to find you guilty of aggravated robbery. I'm going to sentence you to a term of 25 years in the institutional division.
Hey, go. Come on, Mom. Here.
I'm going to sentence you to a term of 25 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. This was not an agreement. You have some rights to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You can talk to Mr. Rojas about any questions you have about that. I am making an affirmative finding of a deadly weapon. Mr. Fontinet, I understand that this is harsh, and I know you believe this is harsh, but I think this is necessary. I hope that you go and you make things right. You can get out of prison. You're still going to be young, and you can make your life better.
And just like that, the decision is made. 25 years in prison for aggravated robbery. A sentence that will define the rest of this young man's life. Let's break this down from a legal standpoint. The judge didn't just rely on the crime itself. She looked at everything. The violent nature of the offense, the presence of a firearm, the psychological impact on the victim, and even the defendant's behavior while in custody. Those jail incident reports? They played a huge role, because they suggested that this wasn't just a one-time mistake. It hinted at a pattern of aggression. And then there's the risk assessment. Being labeled high risk significantly reduces the chances of probation. Courts rely heavily on these evaluations when deciding whether someone is likely to reoffend. So in the end, the judge made a call that prioritized public safety over rehabilitation. But the bigger question still remains, was this justice? Or was this a missed opportunity to change a life before it was too late? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
That's going to be up to you, okay? You can go back with the bailiff.